floor is yours.
Good afternoon, Mr. Commissioner. It's Judah Harrison for the Conservation Coalition, which is a group of non-governmental organizations and individual focused on the conservation of the resource. I know that we have about 45 minutes left and there's 2 more participants, so I've been asked to split the time equally with the First Nations Coalition. I will endeavor to go as fast as I can, and I will be going a little faster than I had intended. If we could start, please, at, it was just marked as Exhibit 1007, please. This is the Riparian Areas Regulation Implementation Guidebook. If you could turn to page 4 of this document, and I believe it might be ringtail 5, but it'll say 4 in the bottom right corner. Oh, back one. In the second paragraph in the middle, thank you. It says, the integrity of a riparian area depends on and is influenced by the upland area as well as the upstream environment. British Columbia has lost hundreds of kilometers of riparian habitat in the past decades in the lower mainland alone. My question, and I'll ask just Mr. Palomi and Mr. Crow, is do you agree with this statement that we have lost hundreds of kilometers of riparian vegetation? And secondly, is this continuing today as we speak?
That's probably a fairly accurate statement.
And would you agree that we are continuing, as we speak today, to continue to lose riparian habitat in the Fraser River?
Yes.
Thank you. Mr. Crow?
Yes, I would agree. We're continuing to lose stream habitat, including riparian.
Thank you. And there has been some discussion, some very helpful discussion on what riparian habitat is. And Mr. Fugere noted that the definition of habitat contains riparian habitat, but I wanted to go to page 12 of this document as well, please. And again, it will be 12 in the bottom right corner. Thank you. The part that's conveniently highlighted in blue says the importance, thank you. The importance of streamside riparian vegetation as fish habitat has successfully been brought before the courts, and legal judgment have identified riparian vegetation as fish habitat. Would you agree with this statement, that riparian vegetation is fish habitat?
Absolutely.
And just taking a small step back, just really simplistically, when I think about habitat, I think about water, riparian vegetation, and maybe rocks and inorganic materials without the stream, in and about the stream. My question is riparian habitat a core element of habitat? When you think of habitat, does that not, a core element of that include riparian habitat?
Absolutely. As I answered Mr. Fugere's question, without healthy riparian habitat, streams change substantially and are unable to support salmon and trout species.
And you have already said this twice, Mr. Crow, but I just wanted to emphasize it. You said that riparian vegetation is particularly important for sockeye species as opposed to other fish.
I wouldn't say sockeye any more than any other salmon and trout. I'd give them riparian vegetation is critical to all of them.
Thank you. So, sorry, it's salmonoids then require intact riparian vegetation more so than other species of fish. Is that fair?
Yes. We generally refer to it as salmonids.
Okay, thank you.
It is to capture salmon and trout. They're essentially much of the same family. That can also includes lake char.
Thank you. And if we can turn to page 24 of this document. (2.1) and 2.2 set out the roles of the various governments. The first one says the role of DFO, and 2.2 is the role of the Ministry of Environment, the provincial ministry. I note that the provincial definition, these are really short, but the provincial role includes monitoring compliance where the DFO does not include monitoring compliance. I would like to ask, is that your understanding of DFO's role in the riparian areas regulation, that it does not include monitoring compliance? And Ms. Wilkerson, would you agree that BC's role does include monitoring compliance?
I would agree that one of the province's roles is to monitor compliance, yes.
Thank you. And Mr. Crow, would you agree that it is not among DFO's role to monitor compliance?
What I would say is explicitly in this document, it doesn't identify it as such. In the there's an operational committee consisting of Union BC municipalities, DFO, and the province. One of its roles is to help coordinate monitoring. DFO could be a participant in monitoring if it so chooses, but as I said a bit earlier, we do leave it to the province to lead the monitoring. We have engaged opportunistically at times.
Mr. Bissett, can you bring up document 5 from Commission Council's list of documents, please, or list of exhibits? Now, this is a draft memo. The subject matter is entitled BC Interior RAR Update. It is dated May 19th, 2006. Like Mr. Crow, Mr. Salome, are either of you familiar with this draft memoranda?
Yes, I am.
Thank you. On the second page of this memoranda, about halfway down, there's a list of what are dubbed RAR weaknesses, or weaknesses with the riparian areas regulation. There's some particular ones. This is halfway down page 2, and then it continues on the next page. But if you go to the next page, Mr. Bissett, the bottom 2 bullets of this part are what I'm focused on. I would like to ask the two of you to read those last 2 bullets and then give your opinion whether these are, this continues to be an issue. And to break the uncomfortable silence potentially, I'll just say that these 2 reference the limitations of using qualified environmental professionals to do habitat assessments. So specifically, I guess I'll ask, this says there are notable risks from reduced government oversight, in particular endorsing that had determination be made by the proponent's consultant. Mr. Crow, would you agree with that?
I would, yes.
Mr. Palomi?
It's Salome, sorry.
Sorry, thank you.
Not that I'm sensitive to that with a name like that. I would agree there are risks.
Thank you. And then the next bullet asks a question. That's what happens if a qualified environmental professional makes a HAD determination DFO doesn't agree with? Would you agree that that is also a problem? Mr. Crow?
Yes, back in 2006 when this was written, this was a substantial concern. It, as I testified earlier, we still are concerned about the judgments of some QEPs, and while I think we have put in place systems to help ensure quality of HAD determinations and an ongoing DFO role, particularly as it relates to these variances, it is still, yes, a concern to us.
Would you agree with me that there's an incentive for qualified environmental professionals to determine that no HAD occurs? In other words, is it fair to say that a third-party consultant will find that no HAD has occurred more readily than a government biologist simply because they're being paid to do so?
Yes, I spoke to this earlier, but my concern is that some of the individuals performing as QEPs have indicated by their track record and decisions that they are not an unbiased professional providing the same advice to their client or to government as I think that they should be.
Okay, thank you.
I should qualify that by saying there are a good group of professionals out there, but there is a component, a contingent that is a problem for us.
Thank you. And what about monitoring or follow-up monitoring? It is my own, if you read these documents or the RAR, is my understanding that follow-up monitoring is often, it is cited that the qualified environmental professional will do follow-up monitoring. Is that fair?
They're expected to do follow-up monitoring. I would ask Ms. Wilkerson to comment on this after me, but the there is nothing to you are supposed to have a follow-up monitoring report, but there's actually nothing that compels the property owner, once they've got their development, to ensure that is conducted and that report is submitted. And there's often no follow-up monitoring, and as I understand it. And again, I asked Ms. Wilkerson to provide her opinion on that.
Ms. Wilkerson?
I agree with what Mr. Crow just said. We do require in a report for a QEP to state that a post-development report is required. We have received them, but there are a large number of reports that have been submitted where we haven't seen post-development report. And again, this it's been a little bit dependent on the QEP. Some QEPs will go in and say, okay, I'm going to provide your assessment, and then I'm going to come back when you start, and I'm going to monitor, and then I'm going to come back when you're finished. And they charge them up front for this, and they come back. Other QEPs will just do the upfront assessment and tell developer you need to hire someone when you're finished. In those cases, it doesn't usually happen in our experience.
Can you bring up document 8 from Commission Council's list, please? Document 8, Mr. Crow, this is an email from you to various people, including Mr. Jason Wong, dated October 6, 2009. The subject is Water Act notifications. I'd like to, do you recognize this email?
Yes, I do.
And is it fair that, this email discusses the SLIP process and talks about its successes, and I would like to take you to you actually touched on this earlier today, but I would like to just emphasize, you do say something here that I think I would like to emphasize again. You say we are having a chronic problem with this substantial regulatory gap. And then further on down, at the very last sentence, in fact, you say, we are facing a problem of ongoing deregulation where everything we knew of the problems facing Shuswap and other lakes is that there is a need to improve management direction. Now, my question to you, you actually, in the other part of this email, talk about how Shuswap worked, and you talk about that necessitated political will. But I wanted to focus on that part of where there's not a political will. Would you agree with me that RAR amounts to deregulation?
I don't know if I would say deregulation. As I said, before RAR, we relied on land development guidelines to provide guidance for development, and we had referral systems for trying to capture and comment on development projects. One of the things I complimented RAR about was actually providing a regulatory standard for development, and I do stand by that agreement, or that statement, that I think that it is, it's not deregulation, it's actually an increase in regulation. My problem with it is actually how it's implemented and some of the mechanisms within the regulation. Sure, there's clearly elements that I disagree with, such as the transference of some authorities to QEPs to make these decisions. So I would say, ultimately, I would not call it a deregulation. I would say it has the potential to be a very powerful and effective tool to protect riparian areas. But what I would add to that is, though, I think it needs to be strengthened in some areas, as we've spoken to earlier.
Okay, well, thank you for that answer. And I'd like to reframe my question, actually. I think you're right. It may not amount to a deregulation, but then I'd like to ask, in your view, is RAR a delegation? I.e., if we look at what we went to earlier, riparian habitat is habitat. And the DFO, as far as we understand, has a mandate to protect habitat. But RAR and all that we're talking about here seems to be a delegation for other people to do their job. Is that fair?
Riparian areas regulation, I think, is an experiment in a new way of delivering environmental protection. And the idea is sound. It's it's a responsibility of all levels of government. That the federal government, provincial government, and local governments all have roles to play here. and but the problem is that some of the people that you're delegating to don't want that delegation. And I think that's the problem, is how to ensure that the local governments are fulfilling an obligation. I think we can point to local governments that want to take on that role, and I will use an example like the city of Kelowna. We never have any problems essentially from that area. I think it's quite a sophisticated government. They have an objective to be for sustainable development, and that works great. But they want to do it. And then we have too many examples where others don't want to. They feel it as a delegation, and I would say that in some fashions, it is a delegation of responsibility. A great idea, but I guess the short conclusion to your question is that it is a delegation.
Thank you. You've talked about the willingness of various municipalities. I just briefly, would you also say that's a problem that many of these municipalities would not have the technical capabilities to do a proper assessment? Is that fair?
First of all, local governments don't do the assessment. It's the QEP who does the assessment and then submits a report. The local government's role is to make a determination within their authority based on the conclusions of that report. So, but I think my answer to your question would be that some local governments who do not want to have that responsibility are not actively cooperating in the effective delivery of the regulation.
Okay. Well, I know the time, and I'm going to leave it there. Thank you very much.
Good afternoon, Commissioner. Crystal Reeves for the First Nations Coalition, and I'll just jump right in, given the interest of time. If you could pull up our tab 7. And my question is directed towards you, Mr. Crow. Are you aware of this report on the foreshore inventory and mapping that was done for DFO and Regional District on Shuswap and Merritt Lakes?
Yes, I am, and I did comment on it briefly earlier, but it wasn't an exhibit at that point, but I made reference to it in answer to slip.
Okay, I'd like that marked as the next exhibit.
2019.
Okay, and what I'd like to do is head to page 39 of the document, and that's the start of the recommendations that were in the report. And at page 39, and 40 and 41, there's a number of recommendations made, including habitat restoration works on page 40, that there should be an identification of core habitat areas on page 41, that there should be a creation of an environmental advisory committee to conduct a development review process, and that SLIP should pursue funding to complete a shoreline management guidance documents. Have you had a chance to review these recommendations?
Yes, I have.
And do you support the majority or all of them that are in this report?
Yes, I support them. The Department of Fisheries and Oceans has reviewed and actually was a key player in the development of this document, and was party and familiar with all these recommendations and agreement with them.
Also on page 43, number 17, maybe I'll just specifically point to, if you could go to recommendation 17 and blow that up, please. And it talks about compensatory works resulting from projects or portions of projects that could not be avoided must follow the DFO decision framework for HAD. And I'm just wondering if there's been any thought given to how that could be done.
Essentially, this is a statement of how we feel all compensatory work should be conducted and related to any development activity that works that have to counterbalance an authorized harm are to be done in such a way that the overall project will meet the no net loss guiding principle of our habitat policy.
And would you like to see that implemented in the Shuswap Lake area then, perhaps through the SLIP process?
I think the SLIP process would be a very good process to help guide and direct how development activities that result in a HAD in Shuswap Lake could best place and determine what type of compensatory work should be conducted.
I'm going to move on now to you, Mr. Salome, in a bit of a different direction. I'm going to take us to Exhibit 746, which is Saving the Heart of the Fraser report. And this was done by Dr. Rossino and Mark Angelo for the Pacific Fisheries Resource Conservation Council. Are you familiar with this report?
I do recall looking at that document, but it was some time ago.
Okay, well maybe I can just talk about some of the impacts they talk about very quickly. On page 79, starting on page 79, they're discussing the impact from agriculture in the Lower Fraser River watershed. And on the fourth paragraph down, it talks about the interplay between construction of dikes and the need for bank stabilization with armoring, or what's known as riprap. Are you aware of that impact and that sort of, I guess, correlation between those two?
Yes.
And would you say that's quite a high impact in the Lower Fraser River watershed?
Yes, historically that's resulted in significant losses of fish habitat.
Okay, and then I'd like to go to page 84. And if you could just blow that up. And it's, I guess, fourth paragraph down, it's the small paragraph there. And it says the area of dike building within the gravel reach is not yet completed. And then it talks about over the past 10 years in the paragraph above, there continue to be numerous upgrades to Fraser River dikes in the Chilliwack area subsequent to hydraulic modeling. So I guess my question is would you agree that dike building in some cases is not just a historic impact but also an ongoing impact in the Lower Fraser River?
Well, without reading the full context here, I think what is suggested there is likely raising of existing dikes. So the actual footprint impact or new impact is often limited if it's just a matter of raising the dike. If it's construction of new dikes or spurs or other features, then perhaps there's more of an impact. But if it's simply raising or upgrading through raising, the new impact is rather limited.
I'd like to move on from that then and go back to you, Mr. Crow, in regards to SLIP again. And if we could pull up Exhibit 1014, please. So, Mr. Crow, is it your experience being involved in the SLIP process that First Nations in that area share your concerns and the perspective of DFO on the importance of habitat and salmon populations and the protection of those?
Generally, yes, but I will qualify that by also saying that we're engaged in discussions with bands at this time with regards to the desire to actually redevelop and create development opportunities on reserve lands as well. So, and that we're having discussions on what appropriate setbacks and development standards should be on reserves. I'd say that generally, absolutely, very, very similar opinions, but you can't. I don't want to generalize and say that all First Nations are in agreement. There are some, including representatives of First Nations government, who would like to see increased development standards and activity on reserve lands, and that we're having somewhat similar challenges as I've described elsewhere on those reserve areas. But for the most part, I would have to say First Nations have very keen interest in the sustainability of the Shuswap Lake area.
Okay, and from my understanding, there are First Nations involvement on the steering committee for SLIP. Is that correct?
That's correct, yes.
Okay. I'd like to go to this report at page 15 of the PDF. And at the bottom there, there's a chart of implementation steps. And can you give us just maybe a brief overview of where those are at in terms of the implementation of some of those steps that are outlined there in the chart?
Sorry, can I ask you to go back and define which, like there's implementation steps for each of the components of SLIP, and if I'm not sure which one these ones refer to.
Well, I think it's...
Or is this the implementation of SLIP in general? But
Yeah.
Within each of the objectives, and there's a separate implementation plan for each one of them. I wasn't sure which one this referred to. This is overview of the key steps.
I guess if you could just comment perhaps on, you know, is an MOU being developed in regards to conflict resolution mechanism? Where is that at?
Sorry, I wonder if it would assist the witness in looking at the previous page, which identifies this is from the section titled Improve the Development Application Review Process.
Okay, thank you. Yes, so within the various streams or objectives of SLIP, some being water quality, some recreational development, this one being foreshore development. There was a plan to create a memorandum of understanding between all the different agencies on how they were going to coordinate and interact in the review of development applications. That was the original intention when this plan was made. It has somewhat changed, and the decision was to go with a terms of reference for that interagency technical review committee, and we never actually created the MOU, but we do have a framework on how we will engage in that technical review committee, as opposed to having an MOU.
And are First Nations on that committee that's been part of that?
I can't say conclusively. I believe that they were invited to be a member, but they might be ex officio. I have never actually seen a First Nations individual attend those meetings. It's really this is a committee that's more specific to the regulatory agencies in how they coordinate their regulatory reviews and decisions. And I don't believe there's First Nations representation on that committee.
Okay.
There is on the steering committee, but I don't believe on this technical committee.
Okay. And I guess then on to page 27, it talks about the need to create a professional and scientific advisory group. Are you aware of that recommendation?
Yes, I am.
How is it envisioned? Who would put the issues to this scientific committee? Would it be DFO or the province or individuals or local government? Who would be putting the issues to this committee?
The idea was that, as it was envisioned, was that the technical committees would, if they ran into an issue where they felt they needed science advice, would make a submission to the steering committee, and the steering committee would then refer that question to this panel of scientists. Yeah.
Okay, and is it envisioned that First Nations would be a part of the science committee in terms of including traditional ecological knowledge and how that might be incorporated?
Within governments, it's always understood that that's an objective. That actual scientific technical committee never was formulated. It was an idea, and the steering committee actually has taken on other priorities, and as far as I'm aware, that scientific committee was never established. I think it was definitely within the normal spectrum of discussions that would be considered in some fashion.
Okay.
Because First Nations is so important to the Shuswap Lake area, and there was a desire to integrate them as much as possible into the SLIP process. It would only make sense that we would try to do it in all components of the process.
Thank you. My next questions are for you, Ms. Wilkerson. First question is, were First Nations ever asked to participate in the development of the RARE?
I don't know. I wasn't involved in the development of the RAR.
And then earlier today, under questioning from, I believe it was Commission, you talked about these monthly meetings between DFO, the Union of BC Municipalities, and the province to sort of coordinate and talk about RARE. Have First Nations ever been invited to participate in those meetings as well?
No, this is a committee that came out of our intergovernmental cooperation agreement between the three parties, and so those have been the only parties that have participated to date.
Right. Do you think it would be useful to invite First Nation representative from, say, perhaps the First Nations Fisheries Council to provide that perspective?
Possibly. I guess it hasn't been considered before because RAR doesn't apply on First Nations lands, and so it's something that I don't think has been considered, but whether or not would be helpful, I'm not sure.
Right, but given the habitat concerns of First Nations, it might be
from
helpful.
that perspective. Possibly, yes.
Okay. And earlier today, also, you talked about how the 2007 audit report, or audit, which is now a draft report for 2009, is going to be made available to the public. Is that right?
That's right.
And what about all the data about which developers, local governments, and QEPs were non-compliant? Would that data be made available to the public?
It wouldn't name specific developers or QEPs, no.
And perhaps then, would you agree that making perhaps this information public, might encourage parties to be more compliant because they would be held to public account?
I guess it's possible.
And what about the possibility of giving this information to First Nations, given that some of the developments would be taking place on traditional territories upon which that development is taking place?
Yeah, if there was an interest for the information, then that could be supplied.
Mr. Crow, back to you. Given government downsizing, what remains a priority for an ecosystem-based management monitoring in your region?
We have tried to align our monitoring with our primary statutory obligations and responsibilities, and that is authorizations under the Fisheries Act, responsibilities under SIA, and Species at Risk Act. Essentially, while we have plans for our monitoring program into the future to address a wide spectrum of development activities, right now we are focusing on confirming that the decisions we are making under our primary statutory obligations are being effective and doing essentially what they're intended to do. So right now, most of our monitoring is focused on that, issues such as our authorizations.
And if you could blow up, I guess, the last few bullets, that's fine. So this was a list of challenges which we've already gone over, and just a few of them is very few stewardship projects can go ahead. There's no longer support to fisheries management to develop First Nations capacity, and no longer able to participate in foreshore planning. Is it accurate that, I guess, in 2007, and this is 2 years after the wild salmon policy has been adopted, that the BC Interior didn't have the capacity to proactively implement it, since each of these items are part of the wild salmon policy?
Essentially, the Habitat Management Program objective is to protect and conserve fish and fish habitats. So essentially, we are trying to deliver, the key objective of the policy, which is the conservation of wild salmon stocks or conservation units. With regards to wild salmon policy processes, the habitat component is really dependent on having a very good, under strategy 2, a very good inventory of habitat values based on assessment studies, understanding of indicators and overall habitat condition. And we essentially don't have a lot of that basic information. So while we're working towards the spirit and intent of WSP, I would say we're not doing it directly within the manner that WSP was envisions or intends.
And what about the SLIP process? Do you see that as maybe being able to assist in the implementation of the wild salmon policy over time?
I mean, yes. Again, it's it essentially is working towards many of the objectives of the wild salmon policy. It's integrating different interests. It's coordinating. It's considering trade-off and values of different parties. We are working towards collecting all the inventory and assessment information necessary to improve our decisions, and it's working within, I think, sort of the general spirit and intent of WSP.
Moving just on to a sort of related issue then to habitat, are you aware of a concern raised by First Nations in the interior with respect to water licensing from agriculture and how that impacts salmon-bearing streams?
I would say that water management issues is one of the greatest challenges we face in the BC interior in terms of ensuring conservation and protection of fish and fish habitat. There's the physical habitat piece, as we've been discussing for the last day and a bit, but we haven't, and I know that water use is going to be a later panel, but the extraction of water for agriculture and other land use issues is a substantial problem in the BC interior, particularly in those areas that are very drought prone, where long extended summers with very little precipitation, and that we share with all others that water use is a very big problem for us. Historically, water licenses were granted with no consideration of in-stream flows. Fish don't even have rights to water right now under the present Water Act. It is proposed for change through the provincial changes to the Water Act under a process called Water Act Modernization. We're very optimistic that will protect and ensure minimum base flows into the future, but essentially water is a very big problem. And I wouldn't say just from agriculture, but agriculture is a big part of that problem with regards to over-licensing of the past and present use.
And has DFO maybe done any mapping of those streams that are of highest concern? I understand from our clients that the Nicola River, obviously now an endangered river, is oversubscribed from water licenses, but has any work been done to identify other streams and rivers that would...
Yes, I mean, the last time that we did an intensive mapping project was actually under the provincial streamside protection regulation, sensitive stream regulation, and we worked with the province to identify streams that were particularly prone to drought problems. I would say that we have not really updated that. In the Kootenays, I can give you an example of an intensive mapping project to identify streams based on sensitivity based on low flows, but I would finish up by saying it should work in the southern interior should be updated.
I'd like to pull up our document, tab 2. And this was a report done by the David Suzuki Foundation called High and Dry, an investigation of salmon habitat destruction in British Columbia. Are you aware of this report?
Yes, I am. I did read it when it first came out. I haven't refreshed my memory of it, but I generally remember, yes.
And Mr. Salome, are you familiar with this report as well?
Yes.
Okay. I'd like that marked as an exhibit.
Exhibit 1020.
And I'd like to just go to page 19 on ringtail. And the fourth paragraph down in the gray there, if we could just go to that paragraph. And this was a conclusion raised by a case that was investigated on Millionaire Creek in Maple Ridge. And citizens had complained about habitat issues there coming from local development. And I won't go through all the details given the time constraints, but it talks about the lack of basically DFO's response in the second paragraph, and then it talked about what the local government did to mitigate the damage that was being done. And I'd just like to have you look through that grade paragraph there. And basically it talks about the new environmental process modernization plan places the onus for fish habitat protection squarely on the shoulders of project proponents and their consultants. And by this, I think they're talking about QEPs, who are deemed qualified professionals. Less emphasis placed on enforcement and more on education. But without the staff or a plan to actually get out in the field and monitor progress, this method of fish habitat management is doomed to failure. A watched industry is a responsible industry. Would you agree with that conclusion, or in I guess mostly the last sentence where we're talking about if industry is watched and monitored, then perhaps they might become more responsible?
What I would say is, and I will try to keep this short, is that a professional reliance model can work. The challenge in an ecological context where we're dealing with such complicated environments, both from a sort of an ecological perspective as well as regulatory, is there's a great deal of uncertainty, and it's not impossible if left an individual's left to his own to apply judgments or discretions that may not necessarily always result in the best outcome ultimately in terms of environmental protection. And my opinion is that the role of government is to provide a level playing field, ensure compliance, and that there is a role to ensure that standards are met by all elements of society, and that I clearly believe professional reliance has its place. I truly believe that government is, one of its roles is to ensure that business is conducted in a fair and accurate manner.
Mr. Salami, do you have any comments? Or would you agree with the statement?
I don't think I have any further comments to add to that.
Ms. Wilkerson, do you have anything you'd like to add about compliance in terms of being able to watch industry and hold them to account under the RARE regulation?
Well, I will. I mean, I agree with what Mr. Crow has said, and I agree. I mean, from my experience with RAR is that many people are willing to comply and quote do the right thing is often how they put it, but when it comes down to those individuals that basically require the hammer in order to comply with what they're supposed to. There are going to be those individuals, and we do run into that. So in those situations, we are a little bit more challenged.
Right, and so do you think that perhaps, I'm just trying to think of possible solutions or recommendations, would you agree that perhaps maybe the QEP course should be made mandatory under the regulation, for instance?
I don't know if that, I mean, most of the QEPs that I'm aware of have taken the course. It tells them how to do it, but I mean, I guess that we're talking about some ideological things that it's not going to teach. So,
right. So then perhaps something like spot checks or actual enforcement provisions through RARE would be a better
yeah,
option.
and we do a lot of spot checks and monitoring, but it is the enforcement piece that becomes an issue.
And I guess my last question is, are you aware of any, I guess, Section 35 or 36 had prosecutions or charges that have come out of the RARE process for either deleterious substances or HADs? Are you aware of that, any of you, that have come out since RARE was implemented?
What I would say is, use an example that Stacy, Ms. Wilkerson is very familiar with, a large commercial development in the Salmon Arm area. There was an appeal mechanism within the regulation that allows third parties who disagree with the outcome to ask for that review, and that was used effectively to change substantially the footprint of that development. I will then point to an example called Old Town Bay at the very east end of Shuswap Lake, very close to the town of Sicamous, where a proponent, a large development company, was aware of RAR, knew of their obligations. They had divided their development into different phases. They had actually applied RAR to one component and therefore obviously knew what was expected of them, and then went forward with developing another part of it without conducting a RAR. And because they had not conducted a RAR, after a thorough investigation that took 2.5 years, we took them to court, and they pled guilty because they had no due diligence. They knew of the standards and the regulations, and because of RAR and their failure to comply with RAR, they pled guilty, and we had a successful prosecution. The single greatest environmental fine in Canada under the Fisheries Act, $300,000 penalty. It was quite an important case for us, and RAR contributed to that.
Okay, thank you. Those are all my questions.
I have nothing arising. I hope my friends don't. Thank you.
Thank you to all council. And I also want to thank Mr. Crow, Mr. Salumi, Ms. Wilkerson for attending and for providing the answers to council's questions and for providing us with your knowledge. Thank you very, very much.
Thank you.
We're adjourned then until Monday at 10 a.m.
Until Monday.
Thank you.
Hearing is now adjourned until Monday at 10 a.m.